morning, everyone. On behalf of Greens List, I hope you've been able to have a bit of a caffeine fix and some carbohydrate loading before we start. I thought when Luke asked me to be chairperson today that I would have an easy job until I saw the CVs of both Diana Price and Therese McCarthy. My first reaction was I must update my own, and terribly impressive that I just don't know really where to start. Diana will be speaking first, and she'll be giving the more criminal aspect of the intervention orders, and then Therese McCarthy will slot in and cover the family aspect of them. Just a bit about Diana Price. If you take the time to read her CV on the website, it's incredibly impressive and embarrassingly so, I might say. She's been practising about 10 years, starting in the ACT, being a Canberrian, as she tells me, and then a foolish sense of adventure led her to the United States. I think she followed a man there, but the foolish sense of adventure. And then she passed the New York bar examination in 2007 and commenced work as a trial attorney for a non-profit firm. So that alone says that she's certainly seen more than I have, and perhaps more than many of the people in this room have. Then she returned to Australia, mainly because family were here, and then started the criminal law with Victoria Legal Aid, came to the bar in 2010 and has practised extensively as a criminal advocate. She also does inquests work and admin law and professional disciplinary matters, and it goes on and on. It's extremely impressive CV, which I wouldn't even attempt to sort of summarise here. She did tell me, though, that she's got a sense of adventure and loves going to small pokey towns, and I think that's a very good attitude to have when you're at the bar. You get sent to Wangaratta, you get sent to Broadmeadows, you get sent to a lot of different places, and she's certainly an extremely vivacious and easy to speak to person. I met Diana, although she's on our list, I only met her this morning, and immediately felt at ease, a lovely person, and I'm sure that if any of you have got any questions either today or in the future, she's someone who's very accessible and very open and easy to talk to. Diana, if you'd like to give your paper now.
Well, thank you, Joanne, for such an introduction, and I feel somewhat under pressure to deliver with that vivacious personality, which I apparently have. Good morning, everyone. Thank you for making such an early start today. And I'm looking forward to addressing you on the topic of intervention orders, with an emphasis on how they connect or relate to contested criminal law matters. No doubt you're all somewhat familiar with the Family Violence Protection Act, which enables the courts to make intervention orders to protect persons who have experienced violent, threatening or abusive behaviour. Now, the number of applications for intervention orders increase every year. I recently looked at the 2012 to 2013 Magistrates Court Annual Report, and in that year there were 33,879 applications for family violence intervention orders, and that was double what the numbers were a decade ago. Now, on one hand, I see this as a positive development if it signals that persons who have been affected by family violence are more likely to contact police and to utilise the courts to ensure their safety. Of course, on the other hand, though, it speaks to perhaps the prevalence of family violence within the community and also brings a certain amount of pressures to bear on the courts, the police and the system as a whole. Now, looking about the room here, I spot people who probably have a defence-based practice, who might be representing respondents more so than anything else. I do know there is probably a mix of criminal lawyers, family lawyers, and I'm even told there are some people here who are civil prosecutors from Vic Police. So I need to be cautious in what I say, because it sounds like amongst the room there is a lot of knowledge here already about intervention orders. Now, when a client approaches you for advice in relation to an intervention order, you typically see them at their lowest ebb. They've either been the victim of family violence, they may have committed family violence, It may be in the context of the end of a relationship or the severance of contact with children. And when you're giving them advice as they navigate through the intervention order process, you may need to turn your mind to how it may relate to criminal law, in the sense that either they will become a complainant in a criminal law matter or perhaps themselves might be charged with a criminal offence. So that's the focus of what I'll be speaking to you about, and Therese will focus more so on the interaction between intervention orders and the family law. Now, firstly, how intervention orders are commenced. I'll do a brief overview of how they begin, how they originate, because that can affect the advice that you give persons early on. 3 ways generally. Firstly, application and summons, application and warrant, or by family violence safety notice. You might be familiar with the usual or the traditional approach where an affected family member makes an appointment with a local magistrate's court, attends the registry, describes the issue, it's translated into the form of an application, which is accepted by the court, and service is arranged on the respondent. Increasingly so, police are lodging applications on behalf of affected family members. This may occur, for example, where police attend the home in response to a call to 000 of an allegation of family violence. When police attend, they of course have their traditional powers to arrest someone who's suspected of committing a criminal offence, but also under the Family Violence Protection Act, they have specific powers to hold and detain persons while police take steps to ensure their immediate safety. And police have options available to them, including the issue of a family violence safety notice, particularly after hours, or during court hours by way of application to the magistrate's court. So firstly, a bit on family violence safety notices. These are currently available after hours, although I hear, and I'd be interested for comments or questions at the end, that there are discussions at a government level about extending the application of safety notices to 24 hours a day. But at present, they're an after hours application. They are issued on the spot. They provide immediate safety on behalf of affected family members and also act as an application and summons towards an intervention order proceedings. It has the benefit of allowing the police to move quite swiftly to impose immediate protection, and it avoids the necessity of going down to the courthouse, lodging an application, which can be quite time-consuming and cumbersome. The attending police officer themselves have to form a view that a safety order is necessary. They would need to accept that there is a necessity and an immediate protection is required in the circumstance. The attending police officer then needs to confer with a senior colleague, someone at the rank of sergeant or above, to satisfy that person also that a safety order is required. If so, a simple form, a prescribed form, is completed. It's served on the affected family member, served upon the respondent, and lodged with the court. At the moment, the safety notice must be made returnable within 120 hours. I hear also there's plans to extend the length of time a safety notice can operate before it needs to be returnable to the court, to perhaps extend it to 5 business days or so. So let's say you get a phone call at the stage at police have served a family violence safety notice. Now, if you're representing an applicant, if you're giving advice to an applicant or an affected family member, you'd be required to advise them about the meaning of a safety notice, what its legal effect is, and that he or she should expect compliance from the person who's been served. If, however, you'll get a phone call, for example, from a respondent in such a matter, great care would be needed to alert them to the fact that if they breach that safety notice, they're at risk of committing a serious criminal offence, punishable by up to 2 years imprisonment, 240 penalty units, or both. If you get a phone call in that situation, it would also be worthwhile preparing the client, if necessary, to participate in a record of interview. What may happen is you get a phone call saying the police are here, they're talking to me about an allegation that I've committed family violence, what should I do? Turn your mind to the likelihood police will issue a family violence safety notice, and also quite possibly they might be arrested, taken to the police station and asked to participate in a record of interview. So it's an opportunity at that stage not only to focus in on the intervention order matter, but to think 1 or 2 steps ahead as to how you can prepare them for perhaps a criminal law proceedings being instituted. Now, it's beyond the scope of what I can talk to you today to go into detail about records of interview, but if you access the Greens List library, it has a catalogue of previous seminars. And my mentor, Sean Cash, has a great paper available online about whether to advise a person to comment or not in records of interviews, so I recommend that to you. Lastly, whether it's an affected family member or respondent, encourage them to attend the return date because final orders can be made. Now, police have the other option of filing an application with the court. They must do so where the respondent is a child or has a cognitive impairment. They also must do that if they knowingly or they are aware that the imposition of a family violence safety notice might conflict with an existing family law order or child protection order. These applications made by police can be made ex parte on the basis of oral or affidavit material, and the magistrate will consider whether an interim is necessary. Probably familiar with the test of interims, whether it is necessary to ensure the safety of an affected family member, preserve property, or protect a child. Then there is a choice of whether to issue a summons or a warrant. A warrant can be chosen where it is the opinion of the registrar or magistrate that it is necessary to ensure the safety of an affected family member and to ensure the respondent attends court. So let's say you get a phone call from a person who has been arrested on a warrant issued in respect of a police application for an intervention order. That happens. Now they have, with this caveat I'll come to in a moment, a presumption to bail. Section 4 of the Bail Act applies so that they may expect to be given bail unless it is established that they're an unacceptable risk of committing further offences or failing to appear. The caveat, however, is that you'll recall there are certain situations where you're in a show cause situation. That is where someone's alleged to have committed an indictable offence while on bail for an indictable offence, or, quite significantly, where they're being arrested for commission of a breach of safety notice or a breach of intervention order where in the past there has been similar matters recorded. It's quite a finicky provision, but subsection 4 is section 4 of the Bail Act, so turn your mind to that in case you get a phone call of someone being arrested in response to a warrant, because ordinarily presumption of bail applies, but in some factual situations that will be displaced. So in this situation, your advice is, of course, breaching an interim order, serious offence, don't do it. For advising an applicant or an affected family member, reporting a breach also can trigger significant police action. If someone is arrested on that warrant and granted bail by the police or the court, remember, now, relatively recently, it is also an offence to breach a condition of bail. So where someone's been given an interim order, released on bail on conditions that substantially replicate the intervention order, you've got a breach there if there's failing to comply with those bail conditions. Now I'll move on to options for resolution, and this is where I think the heart of my paper comes. Usually 4 ways, in my experience: withdrawal of the application, the giving and acceptance of an undertaking, consent without admission, or proceeding to a contested hearing. Now perhaps it is rare where police withdraw outright, where it's a police-initiated application, but it does happen. Sometimes after police have conducted a proper investigation, sought the input perhaps from the Department of Human Services, and if they're satisfied that there is either family violence did not occur or there is no ongoing risk of it doing so again in the future, it's possible that there's a withdrawal there, but perhaps not likely. In some situations, matters may be resolved by way of the offer by the respondent of giving an undertaking or promise to the court, which might satisfy the affected family member or a police applicant. That will depend in situation to situation. And it may be that in situations where the allegation of family violence underpinning the application are serious, it seems unlikely that an undertaking would result. So then, if we take off withdrawal and we take off undertakings, what are we left with? The direction of either consenting without admission or contesting the matter. Now, I will say the vast bulk of these matters resolve by way of consent without admission. And I'd like to focus in on what that actually means. What is the legal import from that? If a respondent consents without admission to the imposition of a family violence intervention order, it means no more than an agreement by that person to be bound by the order of the court. does not constitute an admission of the facts underpinning the application. It does not necessarily concede the necessity of an intervention order going forward. Consenting without admission cannot be used as an implied or actual admission in any subsequent criminal law matter. These are important things to really clarify with a respondent client, because they will often mistakenly think that consent without admission means I'm pleading guilty to having committed an offence. It doesn't. And you may need to reiterate that several times in your advice, because there is often a misunderstanding on behalf of respondents in that situation. Perhaps not surprising though, given the stress that usually accompanies proceedings of this sort. So, perhaps you're heading in the path of a contested hearing. The client also needs to be aware, and applicants as well, that the nature of intervention hearings are completely different from contested criminal matters. Firstly, the standard of proof is a civil standard. There are particular rules which place restrictions on self-represented respondents. For example, they're not allowed to cross-examine protected witnesses, which would include an affected family member. And also, very few rules of evidence apply. So, for example, Section 18 of the Evidence Act, which governs the compellability of family members, doesn't have application in contested family violence matters. There are some remaining laws of evidence that apply. For instance, Section 13 about the competence of witnesses, those provisions that relate to the facilitation of evidence of people through interpreters, also some provisions about privileges and confidential communications, but otherwise the court can inform itself in any way it thinks fit. I should say though, the court does retain a broad power to exclude evidence where it is satisfied it is just and equitable to do so, or where the probative value of the evidence is substantially outweighed by the danger of the evidence being unfairly prejudicial to a party or misleading or confusing. That's a specific rule found within the Family Violence Protection Act itself, not within the Evidence Act. Now, knowing that you're heading in this direction of a contested hearing, and throughout all of the process, you will have no doubt advised about the risks of breach. And there's several breaches that I haven't mentioned. Firstly, people need to be advised about the offence, the specific offence of contravention of an order intending to cause harm or fear for safety. That is an offence punishable by 5 years imprisonment, so substantially longer than a breach without those aggravating factors. And also I note that prosecutors are more commonly proceeding with persistent breaches of intervention orders, which can cover a course of conduct or over a period of time. That also carries that heavier penalty of up to 5 years imprisonment or a fine up to 600 penal units. So, you've got to the crunch point. You've gone through your mention process, you've probably had a directions hearing, you're meeting with a client and a respondent or perhaps an affected family member. And you need to consider what are the pros and cons. I'll now focus my presentation really on if you're acting for a respondent in matters such as this. And I'm thinking particularly of a respondent who may have on the horizon a pending criminal law matter. So that scenario I referred you to at the very outset, where police attend their home in response to a call to OOO. There's an allegation of assault, perhaps there are some injuries. They'll take one route, for example, of applying for a family violence safety notice or an interim order. So you've got a civil proceedings in foot. But also you may have substantive criminal law charges pending. So it becomes more complex where you're advising a respondent who is simultaneously an accused in a related criminal proceedings. And so we'll go through some of the considerations either in favour of contesting the application and also in favour of consenting. Firstly, when it may be appropriate to consent without admission. Now, there are some situations where the priority of the respondent client will be to effect some kind of reconciliation with the family. It might be to reunite with a partner, it might be to have meaningful contact with the children. What I would say is if you're representing a respondent, sometimes an aggressive approach to an intervention order matter can thwart that goal. Sometimes it's better to take a conciliatory approach, discuss resolution of the intervention order without admission, for instance on the basis of limited conditions or in a way that creates a workable parenting plan. In that situation, you may not have much to gain from taking it to the end in terms of contesting an order. Similarly also, it may be a situation where it's appropriate to consent without admission where there is no need or desire for the respondent to have ongoing contact with affected family members. That's more likely to be the case where there are no children of the relationship, but it's worth bearing in mind. Now, of course, I probably should have put this first. Arguments in favour of consenting to an intervention order without admission is where the evidence is overwhelming. There's little to be gained from taking the matter all the way to the end to contest a matter where the evidence is strong, whether it be the cogency of the evidence given by the affected family member, corroborated evidence from the police, photographs, whatever it may be. Just like in a contested criminal law matter, it seems like it's better to resolve. And indeed, if in that situation you have a client who you advise there is merit to consenting without admission, the agreement to that intervention order could be useful plea material down the track. If you ultimately, a couple of months down the track, have to stand up on behalf of someone accused of and is pleading guilty to a family violence offence, it may be more compelling submissions in terms of prospects of rehabilitation and remorse to say, recognised it, consented without admission, and I'm abiding by that order. So bear that in mind. Could be useful plea material if you resolve the intervention order matter. However, there will be cases where the client gives you instructions and there may be a legitimate basis for contesting that criminal law matter on the horizon. So you need to think strategically in the way that you resolve the intervention order case so that it does not prejudice the criminal law matter on the horizon. One reason for consenting without admission would be not revealing a case theory. Now, whatever that may be, if you conduct a contested intervention order matter, the witnesses are certainly put on notice as to what the issues are from a factual perspective. You may also inadvertently reveal any legal arguments or technical arguments that you plan to make. So it may be a case of, if you want to contest that criminal law matter, of keeping your powder dry, so to speak, and reserving those arguments for a contested criminal law matter. The other consideration is where, if you contest this intervention order matter, is your client, the respondent, going to place a harmful admission on the record? In intervention order matters, respondents can give evidence if they wish. If they do not do so, well, then, unfortunately, most of the time the evidence of the affected family member goes unchallenged and it's likely to be accepted. So if going into that contested intervention order hearing, if the client wants to give evidence and the only effective way of giving evidence, great caution needs to be made. Client gets in the box, says something incriminating, makes a few admissions, it's on the record, a canny prosecutor is going to make a note of that, and when you turn up to the contested hearing a few months later, well, there you go. You've got your admissions. So, in that situation, you may be worthwhile advising the client to consent without admission so as to prevent admissions being placed on the record that could harm later defence of a criminal law matter. Now I'll move now on to factors that might weigh in favour of contesting. And I should have said while I give you this list of considerations one way or the other, they're just my own views. They're matters that have occurred to me when I've had briefs from time to time and when I've been in a position to advise people whether to consent or not. So you may agree with some of the submissions or the points that I make, you may disagree. And some of your points may be valid. So I don't pretend that this is an exhaustive list of considerations one way or the other. But when might you contest? In some situations, it can be worthwhile contesting an intervention order on the second limb of the test. The first limb of the test for a final order is, has family violence occurred? The second limb of the test is some kind of predictive criteria of, is family violence likely to occur in the future? You may have a unique factual situation where the alleged family violence is of some age, and there may be a substantial gap in time where nothing of the same sort has occurred. It is possible to run a successful hearing saying that there is no likelihood or very little likelihood of the reoccurrence of family violence. So you could effectively concede one half of the test but dispute the other. Next is whether you want to test the evidence in advance of the contested criminal law hearing. At a contested intervention order, you'll have an opportunity of cross-examining a police applicant or an affected family member. And in that sense, you get a bit of a run of being able to examine the witnesses. Some people might regard this as an advantage, that you get to know your case better in advance of that criminal law hearing. I would say proceed with great caution if that's your strategy. The standard of proof in intervention order matters is completely different, virtually no rules of evidence, and it seems to me the exercise may not be fruitful. And indeed, you would probably run the risk of eliciting more harmful evidence in the course of the contested intervention order hearing than if you just reserved that contest for a later criminal law matter. So some people might regard testing the evidence as a point in favour of contesting, but I would say have some reservations about adopting that approach. Finally, where you've got a client who can't come to terms with consenting without admission, let alone perhaps entering a plea of guilty to an associated criminal law matter. It may be that running the intervention order case for them, if they're unsuccessful, will give you greater information and greater advice to be able to come back and say to them, look, you need to have a sensible resolution of that criminal law matter on the horizon. So you might be in a better position to enter a plea on that associated criminal law matter having contested the intervention order. So in conclusion, there will be cases where it is entirely appropriate to contest an intervention order application. But what I say is that where you've got an associated criminal law matter arising from the same or substantially similar facts, you need to think long term. You need to think about what the consequences are in terms of resolving the intervention order flowing through to your contested hearing. And there are good considerations to advising a client to consent without admission. And throughout the process, not only do I encourage you to give advice about that ultimate question, but there is an opportunity throughout the process of intervention order hearings where there's associated criminal law matters to give meaningful advice at various stages that can, one would hope, ensure compliance with safety notices, prevent breaches of interim orders, prevent breaches of final intervention orders, which, irrespective of whether you're acting for an affected family member or for a respondent, would be in their best interests. Thank you very much.
We're going to have a short break, but I thought if anyone's got any questions now, Diana would be able to answer them, then we'll have a break for more coffee and the like. Has anyone got anything now, or maybe at the end? Mr. Cudler.
Just a very general, fluffy question which doesn't get anywhere. It's been my limited experience that I've had hardly any intervention orders go the whole way. And men and women in the bar who I brief go out and I've got a whole day to spend to have people fall over at the end, as it were. Indicates to me that very, very few, and logistically it takes you so long to get on anyway. Just from your observation and experience, what's your, say, percentile rate of matters going the whole way? It's hard enough for matters going to the DH stage, let alone 9 months down the track and you get to broad your sunshine for a final hearing.
Your perception, I think, your anecdotal perception is right. I don't know what the current statistics are, but a few years ago I appeared before Magistrate O'Reilly when she was sitting in the Family Violence Specialist Division at Heidelberg, and I remember her saying that 96% of matters settle. I don't know whether that's still accurate, but it seems to me it probably is. And it may be because people take a sensible or practical approach to matters. It might be because of the delays, frustration and cause difficulty, or it may be that people prioritise, for instance, the resolution of family law proceedings or outstanding criminal law matters. But you're right, the bulk do settle. And the ones that do run slowly, because when you turn up for a contested hearing, often you're in a list with many other contested hearings in the expectation that the majority of them will not run. So you will find a situation, if you are running a contest, where you get dribs and drabs as the court allows you time. So you're right.